Hello one and all, can you see me? One and all, can you see me? Hello one and all, can you see me? One and all, can you see me? Hello one and all, one and all, hello guys, sorry for delay. There has been some problem in streaming, so let me take couple of seconds of time. By that everything will be all right. So this is my first live session on YouTube. Sorry for delay. Okay. So guys, can you hear me right now? Is my audio and video clear to you? Please do let me know. By that we can start with the lesson. Okay. Ladies and gentlemen, please do let me know, is my audio and video clear to you? By that we can get started with the lesson. Another 30 to 40 seconds, ladies and gentlemen, we will get started with the lesson. So I'm not familiar with these software, so let me take some time before we get started. So here I can see it. One second. One second, let me set the screen again. By that we can get started with the lesson. Another 30 seconds, ladies and gentlemen, please don't mind it. Okay, one second, ladies and gentlemen, one second, please don't mind. One second, there has been some problem with the audio. Let me use another headset. Am I audible to you, ladies and gentlemen, in this at least? Hello Vikash, Sagar, and hello Ashwin Taparia. Another 30 seconds, we will get started. Okay. Am I audible to you? Let us get started. I believe I am audible to you. There is no disturbance in the audio, if I am not wrong. Is there any disturbance in the audio? Couple of people are saying it's audible, and couple of are saying it's not audible. What should we do? Audio is not clear. Let me see. Now without a headset, am I audible to you? Please do let me know. Without. Okay, ladies and gentlemen, there has been some problem with the headset. That's why we have been holding our live session back for some time now. So let us get started. Sorry for making you wait. I believe I can make your time worth for waiting for the last 8 minutes. So let us get started. So ladies and gentlemen, I hope you are having good time in your preparation, since the prelims is around the corner. So you must be waiting to write the examination on June 2nd. So before we get into the topic, let me tell you one thing. You cannot clear your prelims without getting your polity questions right. You have to get at least 80 to 90% of the polity questions right to clear your prelims. So ladies and gentlemen, here I would like to clear another thing, is that in order to clear the prelims, you will have to be thorough in two subjects. The first one is Indian polity, and the second one is environment and ecology. Okay, so here polity questions would be playing a very important role, because 50 to 20% of the questions are from polity. If you could get these 20 questions correct, trust me, you can get more than 50% of the marks, and you can get through the prelims in an open category itself, even though you do have reservation. Hence, ladies and gentlemen, here I have taken this important course that is covering 150 most important polity current affairs MCQs with explanation. And in this particular lesson, that is in the lecture 1, we are going to look at the 25 most important polity current affairs MCQs. Okay, so why do we read these current affairs is a question. So ladies and gentlemen, you must have heard of Lakshmikant's book. So should I be louder, ladies and gentlemen? Please do let me know. So ladies and gentlemen, I'll be a bit louder since aspirants are saying that I'm bit minimized in my tone. So here, reading current affairs relating to the polity is of high importance. So let us get started with the question number 1. Before that, please do subscribe to the Plus subscription of 6 months or 12 months, and you can use the referral code of Rangu Satish for 10% of discount. You can have access to large number of courses if you could get the subscription of 1 year or 2. Okay, so let us get started with the question number 1. The doctrine of progressive realization of rights and non-retrogression was introduced by the Supreme Court in a case related to Section 377 of IPC, privacy as a fundamental right, electoral reforms, and euthanasia. Please do let me know the answer in the comment box. So here the answer is A, ladies and gentlemen, and a couple of aspirants have already written the answer. So the doctrine of progressive realization of rights and non-retrogression was introduced by the Supreme Court in a case relating to the Section 377 of IPC. As you all know, ladies and gentlemen, couple of months back, the Supreme Court of India has taken this case, and they have made the homosexuality as not unconstitutional, or they have removed the homosexuality as being a criminal offense. Okay, so they have given huge amount of rights to LGBT community. So the doctrine of progressive realization of rights is relating to the Section 377 of IPC, and there had been a 4:1 verdict. So let us look at the explanation of it in detail. So the 5-judge constitutional bench led by Chief Justice Deepak Mishra. So at that time it was Deepak Mishra who was Chief Justice of India when this case was delivered. Okay, so zoom into the slides. So okay, slides. Okay, let me maximize the slides. Let me maximize the slide, ladies and gentlemen. I have done it. I think there would be a couple of seconds lag. Okay. Is it okay right now? Okay, let me do a couple of things here. Another 10 seconds, ladies and gentlemen. By that we could figure out where should we keep the slides on. So this is an OBS software where we are teaching in. I'm not familiar with it, so this is lovely. Even though I might not be visible to you in a big font size, however I'm okay with it. So I'm not a celebrity to be seen. Okay, so here the 5-judge constitutional bench led by Chief Justice, sorry. Okay. Another second, ladies and gentlemen. Okay, yeah, we are in. So so the 5-judge constitutional bench led by Chief Justice of India Deepak Mishra has introduced the doctrine of progressive realization of rights to guard against the future attempts to reintroduce that part of section 377 of IPC which had made the entire LGBTQ community unconvicted felons without the basic rights of citizens for over a century. So ladies and gentlemen, here the doctrine of progressive realization of rights means the rights will have to be evolved. So look at the section 377 of IPC. It had been introduced by the Britishers 70 years down on the line of independence. Right after this as well, we are using this particular section. So here there has not been any progressive realization of rights. That is a problem. So here hence Deepak Mishra has said that the rights will have to be evolved. It has to keep on changing as the time progress. Okay, so the doctrine of progressive realization of rights mandate that the laws of a country should be in consonance with its modern ethos. It should be sensible and easy to apply. Using this legal doctrine as a natural corollary, Chief Justice Mr. Mishra has held that once a right is recognized and given to public, it cannot be taken back by the state at a later date. Once a step is taken forward, there is no going back. So what exactly he wanted to say is that the rights given by the Supreme Court of India while interpreting the Constitution of India, once the rights are given, that cannot be taken back by the progressive governments which will come in the future. So once the right is granted, then the government will have to go with it. Okay, so here ladies and gentlemen, another thing what Deepak Mishra had said was our evolving of rights will have to be sensible and easy to apply. Okay, so moving on, the Navtej Singh Johar versus Union of India's case recently in the news is related to triple talaq, section 377 of IPC, Uniform Civil Code, and criminal defamation of India Penal Code. So please do let me know the answer. So ladies and gentlemen, please do write down your answer. Here the question reads, the Navtej Singh Johar versus Union of India case recently in the news is related to triple talaq, section 377 of IPC, Uniform Civil Code, and Criminal Defamation of IPC. So please do let me know the answer. Here a couple of aspirants have said it is B. Let us look at it. Yes, absolutely yes. The answer is B. The case is relating to the section 377 of IPC, and we have seen about the concept of progressive realization of rights in this case in the last question. Another question on this: consider the following events. Section 377 of IPC first challenged in the courts initiation of struggle for a separate state of Telangana, first demonetization in independent India, first preparation of national register of citizens. Which of the following is the correct chronological sequence of the above? So which of the following is a correct chronological sequence of the above events? 4312, 4231, 3421 and 2143. So please do let me know the answer here. And Miss Shashidhar Gowda has said the answer is A, and Mohan Raj has said the answer is D, and a couple of other aspirants have said the answer is A. Let us look at the correct answer here. The correct answer is B, and ironically no one has said the right answer, but we do appreciate the people who have participated in answer. So here the answer is B, ladies and gentlemen. So let us look at the explanation here. In 2001, NAS Foundation Trust, a non-governmental organization, challenged section 377 in Delhi High Court by filing a lawsuit to allow homosexual relationship between the consenting adults. So what we had seen already. And the seeds of Telangana struggle were sown in 1955 when the recommendation of the state's reorganization commission to retain Hyderabad as a separate state went unheeded. Telangana leaders accused the people of Andhra of colonizing the region by grabbing their jobs and land, and the government of not investing in the region's infrastructure. So the state witnessed a violent separate Telangana. So ladies and gentlemen, this is a very comprehensive question where you can get the explanation of 4 points given here. Okay, so coming to another point, that is point 3. Prior to 2016, the demonetization which had taken place in the month of November or December, there were two similar instances in India. The first instance was in 1946 and the second in 1978, when an ordinance was promulgated to phase out notes with denomination of rupees 1000, rupees 5000 and rupees 10,000. So moving on to another important point here, that is NRC. As you all know, NRC is relating to the Assam in order to phase out the illegal migrants of Bangladeshi origin from the Assam state. So it was first prepared in 1951 following the census of 1951. Agitation in this point is not covered here. So here you can ignore this agitation in 1969. This is a continuation of point 2. However, due to some typing mistake, it has been covered here. So moving on to another important question. Okay, so that is D voters recently in the news belongs to a category of voters who are declared a foreigner, by special tribunals under the Foreigners Act. whose names have not been included in the National Register of Citizens, who lacks proper citizenship documents and have been disenfranchised by the government. None of the above. So here what could be the right answer, ladies and gentlemen? Please do write down in the comment box. Here the answer is C, that is D voters are considered to be the doubtful voters who lack proper citizenship documents and have been disenfranchised by the government. So D voters are also common to the state of Assam. Okay, so moving on to another important point here, perhaps. Who is a D voter? So D stands for dubious or doubtful voters. This is a category of voters disenfranchised. Disenfranchised means removed from the list of electoral roll by the government for alleged lack of proper citizenship documents. Some 22.48 lakh people got the D voters tag during NRC process. Okay, moving on to another important question. So this is a question which is apt to the current situation of war kind of situation which is happening between India and Pakistan. So consider the following statement about Article 35A recently in the news. So please do let me know the answer to this. So wing commander returns home, that's a good news, and time to celebrate. So it is a provision incorporated in the Constitution of Jammu and Kashmir. It enables the Jammu and Kashmir legislature to decide who all are the state's permanent residents and confer on them special rights and privileges. No act of the Jammu and Kashmir legislature coming under Article 35A can be challenged for violating the Indian Constitution or any other law of the land. So which of the following statements given above are correct? So which of the following statement above are correct? Option A 1 and 2, option B 2 only, option C 2 and 3, and option D 3 only. Here Shivadeep, Mohan Raj and Pradeep Sampath have said different answers. So let us look at the correct answer here, and the correct answer is C. Okay, so let us look at the explanation here, ladies and gentlemen. So here Article 35A speaks about the permanent residency of the Jammu and Kashmir. As you all know, ladies and gentlemen, we do have 29 states in India. In the 29 states, Jammu and Kashmir has been given some autonomous status by virtue of its agreement with India. Okay, so here there had been a bill on 35A in Supreme Court of India. Hence this particular question has been asked here. So what is Article 35A? So it is a provision incorporated in the Constitution through a presidential order and not by parliamentary debate, giving the Jammu and Kashmir state legislature a complete say in deciding who the permanent residents of the state are, and the state legislature can grant its permanent residents special rights and privileges in public sector jobs, acquisition of property, scholarships and other public aid and welfare programs within the state. So ladies and gentlemen, I believe we are running short of time, and I believe we have to hurry up. By that we can complete all the 25 questions being written here. So I'll take you through the quick explanation of all the questions coming hereafter. Okay, So coming to Article 35A was incorporated in the Indian Constitution by a presidential order, a constitutional amendment, the Constituent Assembly, a Supreme Court. Please do answer this question. I'll give you the 5 seconds. Here the answer is A, ladies and gentlemen, that is a presidential order. So here, as you all know, in order to amend the Indian Constitution, the Parliament approval is required. However, here the constitutional amendment has been done without the approval of the Parliament, that is by the presidential order. Hence, it has included Article 35A. This has raised to the question in Supreme Court of India. Okay, so here there has been a bill in that regard, and the Supreme Court of India has been mulling over it, has been thinking whether to continue with this article or not, which is against the principle of common brotherhood among the citizens of the country, as this particular act would discriminate the person based on the place of living. So moving on to another important question, that is the President of India may by public notification declares that Article 370 shall cease to be operative from such date as he may specify, provided that it shall be necessary for the President to have received prior recommendation of Governor General of India, the Constituent Assembly of Jammu and Kashmir, the Legislative Assembly of Jammu and Kashmir, the Governor of Jammu and Kashmir. Please do let me know the answer. I'll give you 5 seconds of time. Here the answer is B, ladies and gentlemen, that is the Constituent Assembly of Jammu and Kashmir. So ladies and gentlemen, as you all know, there had been an agreement between the then Prime Minister of the country, Jawaharlal Nehru, and the King of Kashmir at that time. So in order to give the separate and autonomous status to Jammu and Kashmir, so in order to fulfill that promise, the Nehru government has given special status or autonomous status to Jammu and Kashmir under Article 370. So this has been accorded in relation to the Constituent Assembly of Jammu and Kashmir. So consider the following statements: the President and the Governor can pardon, reprieve, respite, remit, suspend or commute the punishment or sentence of any person convicted of any offence against the central and state law respectively. The President is the only authority who can pardon a death sentence. So why this question has been covered here, ladies and gentlemen? Because recently the Tamil Nadu government has passed a resolution in Tamil Nadu Assembly for asking for the pardon of the people who have killed the then Prime Minister of the country, Rajiv Gandhi. So which of the following statements given above are correct? Option A, 1 only, option B, 2 only, option C, both 1 and 2, option D, neither 1 nor 2. Here the answer is C. So here is a comparison of pardoning power of the President and Governor. So coming to the President, he can pardon, reprieve, respite, remit, suspend or commute the punishment or sentence of any person convicted of any offence against a central law. Here coming to the Governor, he can pardon, reprieve, respite, remit, suspend or commute the punishment or sentence of any person convicted of any offence against a state law. So you can go through the explanation here. Since we are running short of time, let me cover other questions here. So consider the following statements. As per Kunchi Commission recommendations, the Governor should not have any discretionary powers. Apart from pardoning powers, the Governor's judicial powers include being consulted by the President while appointed the judges of the concerned state high court. Which of the following statements given above is correct? Option A, 1 only, option B, 2 only, option C, both 1 and 2, option D, neither 1 nor 2. Here the answer is B, that is 2 only. So here you can go through the explanation. This is of self-explanatory in nature, so you do not have to worry about anything. So moving on, the Shamsher Singh case, a simple question at a very important question. So the Shamsher Singh case, sometimes in the news, is related to Speaker's powers under the anti-defection law, discretionary powers of the governor, Supreme Court's advisory jurisdiction under Article 143, scope of Article 32. So here the answer is B, that is discretionary powers of the governor. So this question has been asked in relation to the case relating to Shamsher Singh versus State of Punjab, which has been in the news recently. Okay, so moving on, as per the section 124A of IPC, an individual has committed the offense of sedition if he or she by words either spoken or written brings or attempts to bring into hatred or contempt or attempts to excite disaffection towards the government, country, constitution, legislature and judiciary. Select the correct answer using the code given below. Option A, 1 only, option B, 1, 3 and 4, option C, 2 only, and option D, 1, 2, 3 and 4. Ladies and gentlemen, please do let me know your answer. So here Shivani Pandey has said the answer is D, and Shivadeep has also said the answer is D. Let us look at the correct answer. So sorry for disappointing you, ladies and gentlemen. Here the answer is A. So here this is a very important question where I would take you through the explanation. So ladies and gentlemen, since this is my first YouTube session, I might not be up to the mark, but please do forgive me. From the next session onwards, I will be up to the mark and I will deliver the required content and required explanation. Since this is my first YouTube session, please do forgive me, and I would not be repeating the same mistakes again and again, that is managing the time, managing the slideshow here and everything. So I can hear, I can look at some of comments being harsh here, so we'll come to it later on. But Bisali Tongar, here thanks for the answer. Yes, it is D. So study with Bhaskar. Hello sir, hello Bhaskar. Thank you. So here ladies and gentlemen, Khader Wali, good. Okay, so ladies and gentlemen, I know there is some problem with the audio. I'll set it down in the next session. So let me take you through the correct explanation here. So section 124A of the IPC deals with the sedition. Sedition means if you say anything against the government, you would be arrested. Take for example the sympathizers of communism ideology. So if they do say any word against the government, against the established government, then they would be put behind the bars. So under which case would they be booked? Under the sedition case, which is booked under the section 124A of IPC. Okay, moving on to another important question. Described by Dr. B.R. Ambedkar as the very soul and the very heart of the Constitution, it is the preamble, right to freedom, that is protection of life and personal liberty, right to constitutional remedies and directive principles of state policy, Here the answer is C, ladies and gentlemen, that is right to constitutional remedies. As you all know, couple of people have been arrested in Pune recently in relation to the death threat to Prime Minister of the country. So many people have been right away lifted from their universities as being the professors or from their homes without informing on what charges have they been booked. So here Article 32 has been in the question in various editorials, hence I have covered this question here. So Article 32 makes the fundamental rights a real one, because Article 32 says that if any of the fundamental rights of a citizen of the country is violated, then he can enforce it in the court of law. Under Article 32, the Supreme Court; under Article 226, the High Court. Okay, moving on. In which of the following forms does regionalism manifest itself in India? Demand of people of certain states for secession from the Indian Union, demand of people of certain areas for separate statehood, interstate boundary disputes. Select the correct answer using the code given below. Option A 1 and 2, option B 2 and 3, option C 1 and 3, and option D 1, 2 and 3. Here the answer is D, ladies and gentlemen. Sorry Shivani Pandey and Nandini, it's not the right answer. So here the answer is D, that is 1, 2 and 3. Okay, this is an application based question, so you can expect these kind of questions in your prelims examination. So moving on to another important question, that is major obstacles to national integration with reference to India does not include regionalism, casteism, linguism, and none of the above. So please do let me know the correct answer here. Here please do observe the word not include, okay? So please do let me know the answer. So let us move on to the answer, that is D, that is none of the above. So major obstacles to national integration with reference to India does not include regionalism, casteism, linguism. Yes, these are the things which would disunite India and which would disintegrate India. So regionalism, casteism, linguism indeed would be the reasons of disintegration of India, and this would not help in any way of the national integration. Hence the answer is D, that is none of the above. So moving on to another important question, that is, as the leader of the house in a state legislature, the chief minister has the power to advise the governor with regard to summoning and proroguing of the session of the state legislature, recommended the dissolution of the legislative assembly of the governor at any time, announce government policies on the floor of the house. Select the correct answer using the code given below. Option A 1 and 2, option B 2 and 3, option C 1 and 3, and option D 1, 2 and 3. Here the answer is D, ladies and gentlemen. All the statements are correct, and this particular question has been asked as the CM of Telangana, that is KCR, had gone for the dissolution of Telangana Assembly in order to go for an early election. Okay, so moving on, the Constitution provides for a Council of Ministers with Chief Minister at the head to aid and advise the governor in exercise of his function, except the discretionary one. In this context, consider the following statements. If any question arises whether a matter falls within the governor's discretion or not, the decision of the governor is final. The Council of Ministers must always exist to advise the governor even after the dissolution of the state legislative assembly or resignation of a council. Which of the following statement given above are correct? Option A 1 only, option B 2 only, option C both 1 and 2, option D neither 1 not 2. Here the answer is C, that is both 1 and 2, and this particular question has also been asked in the view of dissolution of Telangana Assembly in recent time. So this is one of the repeated question in your CSE, in your prelims. Okay. So moving on to another important question, that is the Constitution provides for the abolition or creation of legislative councils in the states. Accordingly, the Parliament can abolish a legislative council or create it if the Legislative Assembly of the concerned state passes a resolution to that effect. In this context, consider the following statement. Such a specific resolution must be passed by the state assembly by a special legislation. This act of parliament is not to be deemed as an amendment of the constitution for the purpose of article 368 and is passed by a simple majority. Which of the following above statement is are correct? Option A 1 only, option B 2 only, option C both 1 and 2, and option D neither 1 nor 2. So here a couple of aspirants have written the answer already, that is answer A what they have said. However, here the answer is C, and Shivani Pandey has answered it quite well. Okay, so I do really appreciate the aspirants who have been answering here quite now and then. Moving on to another important question. Which of the following state legislatures are not currently bicameral? What is the meaning of bicameral? Having two houses. Look at India, we do have two houses, that is Rajya Sabha and Lok Sabha. Look at the state level, we do have two houses, one is Legislative Assembly, another one is Legislative Council. So this particular question has been asked as there had been a demand from Rajasthan as well as from Odisha in order to create the second house for them, that is in order to create the legislative council for them. Hence this particular question has been asked here. So Madhya Pradesh and Tamil Nadu, Telangana and Madhya Pradesh, Maharashtra and Telangana, Tamil Nadu and Maharashtra. Here the answer is A, and Shivani Pandey and Y3 has got it right along with Imesh Naik. Okay, however Shivadeep has got it wrong, no problem whatsoever, and Miss Kaur has also got it right A, and some of Mohan Raj has also got it right. Okay, so here moving on to another important question. Consider the following statement with reference to ordinance making power of the president. This power of the president in India is not found in most of the democratic constitutions of the world. Whenever a bill seeking to replace an ordinance is introduced in the House, a statement explaining the circumstances that had necessitated immediate legislation by ordinance should also be placed before the House. An ordinance, like any other legislation, can be retrospective, that is, it may come into force from a back date. Which of the following statement above given are correct? Option A 1 and 2, option B 2 and 3, option C 1 and 3, option D 1, 2 and 3. Here the answer is B, that is all of the above, and you can go through this content given here. This would help you in your mains answer writing as well. So moving on to another important question. Which one of the following directions was not issued by the Supreme Court in its recent judgment relating to the criminalization of politics? A contesting candidate is required to inform his or her party about the criminal cases pending against him or her. A political party shall be obligated to uphold on its website information pertaining to candidates having criminal antecedents. A contesting candidate shall give wide publicity about his or her criminal antecedents. A political party shall refuse leadership positions to individuals charged with heinous and grievous crimes such as rape, murder and kidnapping. Here the answer is D. Okay, so moving on to another important question. As per the constitution, ladies and gentlemen, a person shall be necessarily be disqualified for being elected as a member of parliament only if the parliament declares that the holder of a particular office of profit is barred from holding parliamentary membership if he has been found guilty of certain election offences or corrupt practices in elections. Select the correct answer using the code given below. Option A 1 only, option B 2 only, option C both 1 and 2, and option D neither 1 nor 2. Here the answer is D. So moving on to another important question, a simple question, and there have been many questions in this line as well. So that is asking the reports, asking the index, so asking the committees, commissions, everything. So here these kind of questions are very important. These are simple to answer, yet you have to study these kind of questions. We often ignore these kind of questions in our preparation. So the annual public affairs index, which ranks the state of India from the lens of governance, has been developed by which one of the following NGOs? Praja Foundation, Jangraha Public Affairs Center and National Foundation for India. Here the answer is C. So that is Praja Foundation. Okay, so moving on to another important question. So we are running short of time, I believe. Only 9 minutes is left. So which among the following rights are included in the recently released Charter of Parliament Patient Rights by the Ministry of Health and Family Welfare? That is right to information, right to a second opinion, right to free or subsidized medical care, right to protection for patients involved in clinical trials. Select the correct answer using the code given below. Option A 1, 2 and 3, option B 1 and 2, option C 3 and 4, and option D 1, 2 and 4. So I'll give you 10 seconds to answer this question right. Here the answer is D, ladies and gentlemen. And you can go through these rights where you can count it to 16 or 7 kind of rights which have been given by the Ministry of Health and Family Welfare. So when the 10th schedule was introduced in the Constitution by amendment for the first time, it was related to anti-defection laws, Sikkim's association with India, reservation in public employment and fundamental rights. Here the answer is B. So here initially the 10th schedule, okay, 10th schedule was introduced in relation to the Sikkim's association with India. However, it has been repealed and Sikkim has been given the status of a complete state. So later on this schedule has been allocated to the anti-defection law, and 10th schedule has been added to the Indian Constitution by the 52nd Constitutional Amendment Act under the Prime Ministership of Rajiv Gandhi. So consider the following statement regarding social audit in India. Which of the following are correct statement? It is one of the social accountability mechanisms. Meghalaya is the first state in the country to pass social audit legislation. Social audit is an effective tool of good governance. MG Narega mandates social audit by Gram Sabha. So ladies and gentlemen, take 5 seconds of time and answer this question correctly. Here the answer is D, ladies and gentlemen. That is 1, 2, 3 and 4 are correct in relation to the social audit. So coming to another important question, that is a committee on prison reforms was recently set up by the Ministry of Home Affairs, Ministry of Social Justice and Empowerment, Ministry of Law and Justice, and finally the Supreme Court. Here the answer is D, that is Supreme Court of India had recently set up a commission or perhaps a committee to look into the prison reforms, so that would mainly focuses upon the women who have been languishing in jails for years together without getting the bail, and they have been facing certain problems in relation to their daily rituals. Okay, so moving on to the conclusion of this lesson. So ladies and gentlemen, thank you so much for all your respect and continuous support. I knew the class had not been up to the mark. I do accept it. However, ladies and gentlemen, this has been my first YouTube session, and please do forgive me if I had made any of the wrong explanation here. To the best of my knowledge, whatever I have said is absolutely right. So ladies and gentlemen, please do stay tuned to this particular course that is covering 150 important polity current affairs question. By that you can clear your upcoming prelims. So ladies and gentlemen, we will meet on 3rd of March, where we are going to discuss another 25 questions relating to the polity current affairs, and you will see the best of my explanation on that day. Ladies and gentlemen, thank you so much for being with me in this particular lesson. It's been a great honor indeed to get associated with the serious aspirants like you. Thank you so much.